Chapter 4. Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. Competency Component. Black small square integrate into practice the rules governing the activities of life insurance agents. Competency Subcomponents. Black small square explain the role of the organizations that protect clients. Black small square integrate into practice the obligations and responsibilities of life insurance agents. 4. Rules and principles governing the activities of life insurance agents and accident and sickness insurance agents. Ethics and abiding with the rules of professional practice are fundamental to licensed insurance agents. A common objective of insurance regulators is to provide regulatory services that protect the public interest and enhance public confidence in the sectors they regulate. High ethical standards are critical to maintaining the public's trust in the insurance industry and in the profession of insurance agent. Trust and ethical behavior are viewed by clients as important characteristics in their relationship with a life insurance agent. Demonstrating ethical behavior and providing practical advice help build a trusting agent-client relationship. Ethical conduct includes the following. Black small square dealing with conflicts of interest. Black small square client needs analysis. Black small square selling ethically. Black small square meeting fiduciary obligations. Black small square complying with statutes, regulations and codes of conduct. Sanctions for non-compliance with the principles and rules that apply to licensed insurance agents can include important monetary penalties and the revocation of the agent's license. The following sections define important concepts which must be understood and applied by all insurance agents. Black small square role of the organizations that protect clients. Black small square main responsibilities of a life insurance agent. Black small square licensing process and regulations. The examples provided in the sections below demonstrate factual situations which illustrate the concepts and allow future licensed agents to familiarize themselves with the high standards expressed as principles and rules which are expected when carrying out their business. 4.1 Role of the organizations that protect clients. This section identifies the primary regulatory authorities overseeing life insurance agents, and other relevant client protection organizations. It also outlines the regulatory framework regarding the conduct of life insurance agents, and of accident and sickness insurance agents, in Canada, which now increasingly focuses on proactive rather than reactive supervision. 4.1.1 Provincial and territorial regulatory authorities. The federal, provincial and territorial governments legislate and enact regulations for insurance companies. However, federal supervision under the Insurance Companies Act, as well as by the Office of the Superintendent of Financial Institutions, OSFI, is primarily to determine the financial soundness of the federally incorporated life insurance companies, while the provinces and territories are responsible not only to determine the financial soundness of the provincially or territorially incorporated life insurance companies, as the case may be, but also for licensing insurance agents and regulating the licensing of insurers operating within their jurisdictions as well as the marketing of insurance products. 195. The provinces and territories are also responsible for regulating market conduct. According to the Canadian Council of Insurance Regulators, CCIR, market conduct encompasses any product or service relationship between the insurance industry, insurers, agents and individuals alike, and the public. It is influenced by many factors including laws, established best practices, codes of conduct, and client expectations. 196. One priority is risk-based regulation, which directs the regulator's efforts toward issues which could have negative impacts on clients. The CCIR affirms that a risk-based approach could be used to focus regulatory attention on insurers where indicators suggest there is a high risk of non-compliance with the legislation, rather than giving every insurer equal weight and examining them all. 197. In other words, breaches of compliance systematically generate an increased supervision by regulators. Regulatory authorities have a mandate to ensure fair, responsible and professional conduct by life insurance agents. They fulfill their mandate by setting expectations and requirements for regulating the conduct of life insurance agents toward clients, including black small square promoting transparency to clients, black small square taking enforcement actions against breaches of conduct, black small square equipping clients with financial knowledge and skills, understanding financial concepts and terminology, black small square giving clients access to independent complaint resolution avenues, such as the Ombuds Service for life and health insurance. 4.1.2 Provincial and territorial insurance regulators. There are 10 provincial and 3 territorial regulators responsible for the regulation of agents and agencies. 198. As mentioned previously, OSFI is not responsible for the licensing, regulating and supervision of an insurance agent's practice. 4.1.2.1 British Columbia. In British Columbia, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Insurance Council of British Columbia, 199, while the British Columbia Financial Services Authority, BCFSA, 200 issues business authorization to insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Financial Institutions Act, 201, the rules of the Insurance Council of British Columbia, 202, and the Code of Conduct of the Insurance Council of British Columbia. 203. There is no specific chapter regarding agents in the Insurance Act. 204. However, the Financial Institutions Act contains certain relevant provisions relating to insurance agents. 4.1.2.2 Alberta. In Alberta, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Alberta Insurance Council, part of the Alberta Treasury Board and Finance. Financial Sector, Regulation and Policy, 206, while the Office of the Superintendent of Insurance of Alberta 207 licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 208 and the Life Insurance Council Code of Conduct. 209. 4.1.2.3 Saskatchewan. In Saskatchewan, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Life Insurance Council of Saskatchewan, 210, while the Financial and Consumer Affairs Authority of Saskatchewan, Insurance and Real Estate Division, 211 licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Saskatchewan Insurance Act 212, the Life Insurance Council Guidance Notes 213 and the Life Insurance Council Bylaws. 214. Please note that on January 1, 2020, the Saskatchewan Insurance Act was replaced by the Insurance Act. 215. You will find a Schedule 3 that you may use as a Table of concordance between the relevant sections of the Saskatchewan Insurance Act and the Insurance Act. In Saskatchewan, in order to be allowed to distribute segregated funds, a life insurance agent must have completed a course recognized by the Life Insurance Council of Saskatchewan. The passing of all four LLQP modules is an approved course. If a life insurance agent is not allowed to sell segregated funds, a restriction will appear on his license. 216. It is important to note that the Managing General Agent, MGA, and the Third-Party Administrator, TPA, licenses also exist in Saskatchewan. 217. 4.1.2.4 Manitoba. In Manitoba, life insurance agents and accident and sickness insurance agents are licensed by the Insurance Council of Manitoba, 218, while the Manitoba Financial Services Agency, Financial Institutions Regulation Branch, FIRB, 219 licenses the insurance companies. There is no license for corporate agencies. However, it is possible to find an agent through an agency search. 220. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act, 221, the Insurance Agents and Adjusters Regulation 389/87, the Life Insurance Agents and Accident and Sickness Insurance Agents Licensing Rules, and by the Life Insurance and Accident and Sickness Agents Code of Conduct. 222. 4.1.2.5 Ontario. In Ontario, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Financial Services Regulatory Authority of Ontario, FSRA, in replacement of the Financial Services Commission of Ontario, FSCO, 223, which also regulates insurers. That replacement occurred on June 8, 2019. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 224 and by the Agents Regulation 225, the replacement of Life Insurance Contracts Regulation 226. The Unfair or Deceptive Acts or Practices Regulation 227, the Variable Insurance Contracts Regulation 228, the Administrative Penalties Regulation 229, and the Code of Ethics for Life Insurance Agents in Ontario, which does not have legal effects, unlike the Code of Conducts in British Columbia, Alberta and Manitoba. 230. Other regulations have come into force on July 1, 2016. 231. 4.1.2.6 Quebec. In Quebec, life insurance agents, accident and sickness insurance agents, insurance brokers and independent agencies are licensed by the Autorité des Marchés Financiers, AMF, 232, which also regulates insurers. However, the discipline of life insurance agents and accident and sickness insurance agents is the responsibility of the Chambre de la Sécurité Financière, CSF, while the AMF is responsible for the supervision and discipline of corporate agencies, firms and independent partnerships. 233. Life insurance agents and accident and sickness insurance agents are governed by an act respecting the distribution of financial products and services, 234, by the regulation respecting firms, independent representatives and independent partnerships, 235, the Code of Ethics of the Chambre de la Sécurité Financière, 236, the regulation respecting the issuance and renewal of representatives certificates, 237, the regulation respecting the pursuit of activities as a representative, 238. The regulation of the Chambre de la Sécurité Financière respecting compulsory professional development, 239. The regulation respecting the registration of firms, representatives and independent partnerships, 240. The regulation respecting information to be provided to consumers, 241, and the regulation respecting the keeping and preservation of books and registers, .242. 4.1.2.7 New Brunswick. In New Brunswick, life insurance agents and accident and sickness insurance agents are licensed by the Financial and Consumer Services Commission, FCNB, 243, which also licenses insurance companies. License for corporate agencies and managing general agents, MGAs, are now required, 244. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act, .245. 4.1.2.8 Nova Scotia. In Nova Scotia, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Office of the Superintendent of Insurance, part of the Nova Scotia Department of Finance and Treasury Board, Office of the Financial Institutions Division, 246, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. .247. 4.1.2.9 Prince Edward Island. In Prince Edward Island, life insurance agents and accident and sickness insurance agents are licensed by the Prince Edward Island Superintendent of Insurance, part of Justice and Public Safety, Consumer, Corporate and Financial Services Division, 248, which also licenses insurance companies. There is no license for corporate agencies. Non-resident corporate agencies are required to register under the Extra-Provincial Corporations Registration Act, RSPEI 1988, CE 13. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 4.1.2.10 Newfoundland and Labrador. In Newfoundland and Labrador, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Superintendent of Insurance, part of Service NL, Financial Services Regulation Division, 250, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Adjusters, Agents and Brokers Act. .251 The Insurance Companies Act 252, the Insurance Contracts Act 253, the Life Insurance Act 254 and the Accident and Sickness Insurance Act 255 are equally relevant. 4.1.2.11 Yukon. In Yukon, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, Department of Community Services, Professional Licenses and Regulatory Affairs Branch, 256, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. .257. 4.1.2.12 Northwest Territories. In the Northwest Territories, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, part of Finance, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. .258. 4.1.2.13 Nunavut. Since April 1, 2013, The government of Nunavut administers its powers under the Insurance Act itself. This is done through the Office of the Superintendent of Insurance of Nunavut, part of Finance. Prior to that date, the Nunavut Insurance Act was administered by the Office of the Superintendent of Insurance of the Northwest Territories. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 260. 4.1.3 Canadian Insurance Services Regulatory Organizations, CISRO. The Canadian Insurance Services Regulatory Organizations, CISRO, defines itself as an interjurisdictional group of regulating authorities who are dedicated to developing consistent standards of qualifications and practice for insurance intermediaries dealing in insurance of persons and property. 261. The principal responsibility of the members of CISRO is to administer the regulatory system applicable to insurance intermediaries, under their authority. Although CISRO members cannot enact legislation, they are key advisors to their governments on regulatory issues related to insurance intermediaries. The CISRO website includes a link to disciplinary actions taken by insurance regulators. This provides transparency to both the industry and clients. 262. The regulatory authorities also work with other authorities and agencies through the Joint Forum of Financial Market Regulators, and maintain constructive dialogue with client associations on issues confronting the life insurance buying public. In September 2018, CISRO, in collaboration with CCIR, has published a guidance entitled Conduct of Insurance Business and Fair Treatment of Customers, which applies to insurers as well as insurance intermediaries, individual agents, brokers and representatives. According to the guidance, fair treatment of customers encompasses concepts such as ethical behavior, acting in good faith and the prohibition of abusive practices. Ensuring fair treatment of customers encompasses achieving outcomes such as black small square developing, marketing and selling products in a way that puts customers' interests ahead of their own. Black small square providing customers with accurate, clear, not misleading and sufficient information before, during, and after the point of sale, which will allow him to make informed decisions. Black small square minimizing the risk of sales which are not appropriate to the customer's needs. Black small square ensuring that any advice given is relevant. Black small square dealing with customer claims, complaints and disputes in a fair and timely manner. Black small square protecting the privacy of customer information. 4.1.4 Other authorities providing client protection. There are a number of other authorities that protect the client. Those most relevant to the activities of a life insurance agent are discussed below in the following order. Black small square Office of the Privacy Commissioner of Canada. Black small square Financial Transactions and Reports Analysis Centre of Canada, FINTRAC. Black small square Assuries. Black small square Ombuds Service for Life and Health Insurance, OLHI. Black small square Canadian Council of Insurance Regulators, CCIR. 4.1.4.1 Office of the Privacy Commissioner of Canada. The mandate and mission of the Office of the Privacy Commissioner of Canada is to administer enforcement of the Federal Personal Information Protection and Electronic Documents Act, PIPEDA, Canada's private sector privacy legislation, and to protect and promote the privacy rights of individuals. 263. Life insurance agents operating in British Columbia, Alberta and Quebec are subject to their Own province's Personal Information Protection Act. Agents should recognize that they have a responsibility to keep client information confidential and to secure that information. 264. Example. Nancy, a licensed life insurance agent in Manitoba, kept her client files in an unlocked cabinet in her office or on her computer, which had her password taped to the keyboard. Her office was broken into, her files rifled and her computer stolen. Nancy did not comply with PIPEDA. She should have made sure the files were kept in a secure place. 4.1.4.2 Financial Transactions and Reports Analyses Centre of Canada, FINTRAC. The Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, Canada's Financial Intelligence Unit, was created in 2000. It is an independent agency, reporting to the Minister of Finance, who is accountable to Parliament for the activities of the Centre. It was established and operates within the ambit of the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCMLTFA, and its regulations. FINTRAC's mandate is to facilitate the detection, prevention and deterrence of money laundering and the financing of terrorist activities, while ensuring the protection of personal information under its control. It fulfills its mandate through the following activities. Black small square receiving financial transaction reports in accordance with the PCMLTFA and regulations and safeguarding personal information under its control. Black small square ensuring compliance of reporting entities with the PCMLTFA and regulations. Black small square producing financial intelligence relevant to investigations on money laundering, terrorist activity, financing and threats to the security of Canada. Black small square researching and analyzing data from a variety of information sources that shed light on trends and patterns in money laundering and terrorist financing. Black small square maintaining a registry of money services businesses in Canada, and Black small square enhancing public awareness and understanding of money laundering and terrorist activity. Financing. 265. In general, an insurance of persons representative who offers products on behalf of a single insurer acts as mandatory of that insurer. A representative who acts on behalf of several insurers is the mandatory of one of them when he carries out acts on behalf of that insurer. Such acts may be one of those described below. When ascertaining the client's identity, the Proceeds of Crime, Money Laundering, and Terrorist Financing Act 266 is important. Its purpose is to detect individuals and companies involved in criminal activities, and to deter money laundering. Insurance representatives are part of the process, because permanent and universal life insurance products as well as non-registered annuity contracts can be used as a means to create, accumulate and transfer wealth. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the Act, introduces mechanisms to ensure that the right person or entity is dealt with, to identify individuals and entities taking part in criminal activities and to discourage money laundering. An insurance of persons representative has specific obligations under the Act and its regulations in order to help combat money laundering and terrorist financing in Canada. The representative is required to verify the identity of any person or entity, hereinafter, the client, or the beneficiary, for whom an information record is kept regarding the sale of an immediate or deferred annuity or a life insurance policy. Black small square for which the client may pay $10,000 or more over the duration of the annuity or policy. Black small square for which a beneficiary may receive $10,000 or more over the duration of the annuity or policy. FINTRAC defines beneficiary as the individual or entity that will benefit from a transaction or to which the final remittance is made. 267 This very broad definition covers any annuity payment or surrender transaction, in addition to death benefit payments. The representative must therefore, on the one hand, verify the client's identity in connection with the sale, if the client may pay $10,000 or more over the duration of the annuity or policy. On the other hand, he must verify the identity of the beneficiary indicated in the information record before the first payment is made to the beneficiary, if that beneficiary may receive $10,000 or more over the duration of the annuity or policy. In all cases, the identity must be verified within 30 days of the creation of the information record, regardless of the means of payment. The representative must at all times record the required information in the client's file. 268. Moreover, an identity need not be verified again if black small square the identity of an individual has already been verified or the existence of an entity has already been confirmed using a method permitted by the Act and its regulations. Permitted methods are discussed later. Black small square the required documents are kept on file, and black small square no doubt remains as to the information obtained. Specific exceptions apply to the identity verification obligation. For example, an insurance of person's representative is not required to verify the identity of a person or confirm the existence of an entity at the time of purchase of a registered individual or group annuity contract, RRSP, RRIF, LIRA, LIF, DPSP, RPP, TFSA, etc., exempt life insurance contract, 269 and accident and sickness insurance contract without a cash surrender value. However, in some circumstances, an identity verification may nevertheless be required by the insurer for exempt plans or products. Where applicable, an identity verification allows the insurer to confirm the client's age or comply with its obligations under the Foreign Account Tax Compliance Act, FATCA, 270 and the Common Reporting Standard 271. Parts 18 and 19 of the Federal Income Tax Act, two international initiatives aimed at countering tax evasion by citizens or residents of other countries with accounts in Canada, and vice versa. For non-exempt insurance and annuity contracts, the insurance of person's representative is required to verify the client's or beneficiary's identity using one of the methods permitted by the Act and its regulations. The representative must do so for each policyholder or owner, including any co-policyholders, and for each beneficiary. Under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the representative is required to properly verify the client's identity. Methods to verify the identity of persons and entities, 272. FINTRAC describes 5 methods to verify the identity of a person or an entity. 273 The approach depends on the type of client or beneficiary, individual, corporation or other entity, and the context. In the client's or beneficiary's presence or absence, 274. 1. Government-issued photo identification method. White small square the identification document must show the individual's name and contain the individual's photo. The document must be valid, current and original. White small square the document must contain a unique identification number. White small square. The name and photo on the document must match the name and appearance of the person being verified. Some examples include a Canadian passport, a permanent resident card, a secure certificate of Indian status, a driver's license, and provincial or territorial identification cards. In Quebec, an insurance representative cannot ask to see a person's health insurance card, but can accept it if that person presents it for identification purposes. In Ontario, Manitoba, Nova Scotia or Prince Edward Island, such use is prohibited. A social insurance card may not be used to verify identity, and a social insurance number, SIN, may not be used in a report made to FINTRAC.275 ASIN. Is used for tax purposes only and is required to that end in some types of insurance of persons contracts. When verifying someone's identity based on a piece of photo identification, a representative must obtain and record the following information. Black small square. The name on the photo identification. Black small square. The type of photo identification used. Black small square. The photo identification reference number. Black small square. The place the photo identification was issued. And black small square. The expiry date of the photo identification. 2. Credit file method. A credit file is used as an identification method to verify the identity of a person who is not physically present. This method requires that consent first be obtained from the client or beneficiary before consulting the information contained in the credit file. A specific independent identification product is then used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada. It is important to note that Canadian credit bureaus offer independent identification products that can be used to consult a credit file for identity verification purposes without affecting a person's credit score. To use the credit file identification method, the search has to be performed at the same time as the identity verification. A credit file cannot be used if it was obtained at an earlier date or if a copy was provided by the person to whom the file applies. The search results must meet the following criteria. Black small square. The client's or beneficiary's credit file must have at least 3 years of history and must contain valid and current information. Black small square. The name, address and date of birth in the credit file must be the same as those provided by the client or beneficiary. Black small square. The credit file must be Canadian, as foreign credit files are not accepted, and the information in the credit file must be derived from more than one source, i.e., from more than one trade lane. The copy of the search results from Canadian Credit Bureau databases must be kept in the client file, the report produced by the Canadian Credit Bureau, and must contain the following. Black small square. The source of the credit file, for example, the name and logo of the credit bureau. Black small square. The name of the person whose identity is being verified. Black small square. The credit file reference number, and black small square. The date the credit file was consulted. Where a Canadian credit bureau cannot authenticate even just one item of information on the client or beneficiary, for example, if the first name, last name, date of birth or address does not match, or if the credit file is not Canadian, has less than 3 years of history or is derived from a single source, a single trade lane, the credit file method alone cannot be used. At this point, another method must be used to verify the client's or beneficiary's identity. 3. Dual process method. The dual process identification method is used to verify the identity of a person that is not physically present. It requires performing two actions, consulting two independent credit transactions or referring to two reliable and distinct sources to verify a client's or beneficiary's identity. On the one hand, a specific independent identification product can be used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada. As the aggregator, to compile information from two independent credit transactions dating back at least 6 months. The client's or beneficiary's consent must have been obtained first. These two credit transactions must have been carried out by the client or beneficiary with two independent and distinct business sources and must have two of the following three matches. Black small square the client's or beneficiary's name and address. Black small square the client's or beneficiary's name and date of birth, and/or black small square the name and existence of a financial account in the client's or beneficiary's name with a financial institution. Where a Canadian credit bureau cannot make two of the three matches mentioned above using two independent credit transactions dating back at least 6 months, another solution must then be used to verify the client's or beneficiary's identity. Various combinations are possible. Below are two examples. Black small square an analysis of the search results from Canadian Credit Bureau databases yields a first match from among the ones mentioned above. For example, the Canadian Credit Bureau matched and confirmed the name and date of birth of the client or beneficiary, and the verification of a document from a reliable source yields a second match, for example, a statement issued by a Canadian federal government agency confirms the name and address of the client or beneficiary, or black small square an analysis of the search results reveals that the Canadian Credit Bureau was unable to obtain any of the three matches mentioned above, in which case the representative must refer to information from two reliable and distinct sources, such as white small square a statement issued by a Canadian federal government agency to confirm the person's name and address, first match, and white small square a deposit account statement confirming the person's name and the fact that he holds a deposit account in a financial entity, second match. The information obtained must be valid and current and must be derived from different reliable sources. 276 examples include statements, letters, certificates, forms and other admissible and reliable information sources. 277. In all cases, the information provided by the client, first and last name, address and date of birth, must be the same as those obtained from the Canadian Credit Bureau or derived from reliable and distinct sources. The following details must be recorded. Black small square the name of the person whose identity is being verified. Black small square the date the information was consulted. Black small square the name of the two different sources used to verify the person's identity. Black small square the type of information used, for example, a utility account statement, bank statement or marriage certificate. Black small square the number associated with the information, for example, the account number or reference number, and black small square the account number associated with each trade lane for information aggregated by a Canadian Credit Bureau. 4. Affiliate or member method. The identity of a person or an entity can be verified by confirming that one of the following entities has previously performed such a verification. Black small square an affiliate that is one of the following reporting entities: res, bank, foreign bank, cooperative, credit society, savings and credit union, caisse populaire, life company, foreign life company, trust company, loan company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities or any other financial instruments, or to provide portfolio management or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity. An affiliate carrying out outside of Canada activities similar to those listed above. Black small square, a financial entity subject to the proceeds of crime, money laundering, and terrorist financing Act and member of the Financial Services Cooperative or Credit Unions Central of the Insurance of Persons representative carrying out the verification. The name, address and date of birth in the records of the affiliate or the member financial entity must match the information provided by the person whose identity is being verified. For a corporation or other entity, the records of the affiliate or member financial entity must state that an admissible document was used and retained to confirm its existence, and that its name, its address, and the names of its directors were verified and recorded. The affiliate or member financial entity must have previously verified. Black small square the identity of the person using the government-issued photo identification method, credit file method or dual process method described earlier, or black small square the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the affiliate or member financial entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the proceeds of crime, money laundering, and terrorist financing regulations using the methods in place at the time of the verification. When an affiliate or a member financial entity has previously verified a person's identity, the following information must be recorded. Black small square the name of the person or entity whose identity was verified. Black small square the date the identity was verified. Black small square the name of the affiliate or member financial entity that verified the person's or entity's identity. Black small square the method used to verify the person's or entity's identity, and black small square the information and or documents recorded by the affiliate or member financial entity according to the method used, including the date the identity was verified by the affiliate or member financial entity. 5. Reliance method. A person's or entity's identity can be verified by relying on the measures already taken by black small square another re from among the following: bank, foreign bank, cooperative credit society, savings and credit union, caisse populaire, life company, foreign life company, trust company, loan company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities or any other financial instruments, or to provide portfolio management or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity, or black small square an entity that is affiliated with the insurance of persons representative, or with another re and carries out activities outside of Canada that are similar to those listed above, i.e., an affiliated foreign entity. When another re or an affiliated foreign entity has previously verified a person's or entity's identity, the information recorded and the documents required must be promptly obtained from the other re or affiliated foreign entity. This information and documents must be valid and current and must match those provided by the person or entity whose identity is being verified. The other re or affiliated foreign entity must have previously verified black small square the identity of the person using the government-issued photo identification method, credit file method or dual process method described earlier, or Black small square the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the other or affiliated foreign entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the proceeds of crime, money laundering, and terrorist financing regulations using the methods in place at the time of the verification. In addition, the other or affiliated foreign entity must have had a written agreement or arrangement that requires all of the information it had referred to in order to verify the person's identity to be provided as soon as feasible upon request. Using a mandatory to verify the identity of a person. The insurance of persons representative can use a mandatory acting on his behalf to verify the identity of a person. A written agreement must previously have been reached with the mandatory. To this effect, the representative remains responsible for the identity verification under the Act and its regulations, even though this task is entrusted to the mandatory. Any mandatory who verifies a person's identity on behalf of a representative must black small square use the government-issued photo identification method, credit file method or dual process method described earlier. Black small square satisfy the current requirements for each of these methods, and black small square record the required information. If the mandatory verified the person's identity prior to June 1, 2021, he must have done so pursuant to the proceeds of crime, money laundering, and terrorist financing regulations using the methods in place at the time of the verification. The information obtained must meet the criteria for verifying the person's identity. Verifying the identity of a corporation or other entity. To verify the identity of a corporation, an insurance of persons representative must consult one of the following documents. Black small square a certificate of incorporation. Black small square a record that the corporation has to file annually under provincial securities legislation, or black small square the most recent version of any other record that confirms the corporation's existence and contains its name and address and the names of its directors, SUWWCH as a certificate of active corporate status, the corporation's annual report signed by an audit firm, or a letter or notice of assessment for the corporation from a municipal, provincial, territorial or federal government. The record used must be authentic, valid and current. The insurance of persons representative must obtain the corporation's name and address and the names of its directors. To do this, a search may be performed in a provincial database, such as that of the Registre des Entreprises du Québec, or federal database, such as the Corporations Canada database. The insurance of persons representative can also obtain this type of information by subscribing to an online corporation search and registration service. To verify the identity of an entity other than a corporation, the insurance of persons representative may use black small square a partnership agreement, black small square articles of association, or black small square the most recent version of any other similar record that confirms its existence and contains its name and address. To verify the identity of a trust, the insurance of persons representative may use the deed of trust, or, in the case of a testamentary trust, the will. To verify the identity of a succession, the insurance of persons representative may use a copy of the death certificate and the last will and testament of the deceased person. The record used must be authentic, valid and current. If the insurance of persons representative consults a paper or an electronic record, he must keep that record or a copy of it. If the insurance of persons representative consults the electronic version of a record from a database accessible to the public, he must keep a record that includes the corporation's or other entity's registration number, the type of record consulted and the source of the electronic version of the record. Signing authority resolution, corporations. When the client or beneficiary is a corporation, the insurance of persons representative must obtain a signing authority resolution clearly designating the individuals duly authorized to act and sign on behalf of the corporation. This record derives from the corporation's official registers and must be signed by all board of directors members entitled to vote on this resolution. Examples of documents to be used as a resolution include the certificate of incumbency, meeting minutes and the corporation's bylaws. A corporation is a legal entity separate from its shareholders. It may be incorporated under provincial or federal legislation and usually has a permanent existence until its dissolution. Its aim is to operate an enterprise for the purpose of generating profit that will be distributed, as applicable, among its shareholders. Information on the ownership, control and structure of entities. The insurance of persons representative must obtain information describing the ownership, control, and structure of entities. Black Small Square Corporation. The names of all its directors and the names and addresses of all its beneficial owners. Black Small Square Trust. The names and addresses of all trustees, known beneficiaries and known settlers of the trust. Black Small Square Widely Held or Publicly Traded Trust. The names and addresses of all trustees and the names and addresses of all beneficial owners. Black Small Square Succession. The names and addresses of all liquidators or individuals who have control over the succession. Black Small Square Other Entity. The names and addresses of the beneficial owners. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the information obtained and must keep the records in which the required information appears when that information is first obtained and in the course of conducting ongoing monitoring of business relationships. Verification of beneficial owners 279. The insurance of persons representative must obtain the required information on beneficial owners pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations. Beneficial owners are the individuals who directly or indirectly own or control 25% or more of a corporation or an entity other than a corporation. In the case of a corporation, the beneficial owners are often its shareholders. In the case of a trust, they are the trustees, the known beneficiaries and the settlers of the trust. In the case of a widely held or publicly traded trust, they are all of its trustees as well as all persons who directly or indirectly hold or control 25% or more of its units. In the case of a succession, they are its liquidators. Beneficial owners cannot be other corporations, trusts or other entities. They must be the individuals who are the owners or controllers of the entity. It is necessary to search through all the possible layers of information of the chain of control of the corporation or other entity in order to determine the beneficial owners. It is important to consider and review the names found in the corporate, government or legal documents consulted in order to make certain that they match the names of the individuals who have actual ultimate control of the corporation or other entity. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the beneficial ownership information when that information is first obtained and in the course of conducting ongoing monitoring 280 of Business Relationships. 281. Third-party determination requirements. A third party is the person or entity that instructs another person or entity to conduct an activity or financial transaction on their behalf. As such, the third party is the instructing party as to the handling of the money or the performance of the transaction or activity in particular, and is also understood to be the on behalf of party. The insurance of persons representative must take reasonable measures to determine whether a third party is involved when a transaction or activity is carried out. This verification is carried out in order to identify a person or an entity that takes part in criminal activities relating to money laundering and terrorist activity financing, and that has another person or entity carry out a financial transaction in its place. Reasonable measures for third-party determination include asking the client if they are acting at the instruction of another. Chapter 4. Rules and principles governing the activities of life insurance agents and accident and sickness insurance agents. Competency component. Black small square integrate into practice the rules governing the activities of life insurance agents. Competency sub-components. Black small square explain the role of the organizations that protect clients. Black small square integrate into practice the obligations and responsibilities of life insurance agents. 4. Rules and principles governing the activities of life insurance agents and accident and sickness insurance agents. Ethics and abiding with the rules of professional practice are fundamental to licensed insurance agents. A common objective of insurance regulators is to provide regulatory services that protect the public interest and enhance public confidence in the sectors they regulate. High ethical standards are critical to maintaining the public's trust in the insurance industry and in the profession of insurance agent. Trust and ethical behavior are viewed by clients as important characteristics in their relationship with a life insurance agent. Demonstrating ethical behavior and providing practical advice help build a trusting agent-client relationship. Ethical conduct includes the following. Black small square dealing with conflicts of interest. Black small square client needs analysis. Black small square selling ethically. Black small square meeting fiduciary obligations. Black small square complying with statutes, regulations and codes of conduct. Sanctions for non-compliance with the principles and rules that apply to licensed insurance agents can include important monetary penalties and the revocation of the agent's license. The following sections define important concepts which must be understood and applied by all insurance agents. Black small square role of the organizations that protect clients. Black small square main responsibilities of a life insurance agent. Black small square licensing process and regulations. The examples provided in the sections below demonstrate factual situations which illustrate the concepts and allow future licensed agents to familiarize themselves with the high standards expressed as principles and rules which are expected when carrying out their business. 4.1 Role of the organizations that protect clients. This section identifies the primary regulatory authorities overseeing life insurance agents, and other relevant client protection organizations. It also outlines the regulatory framework regarding the conduct of life insurance agents, and of accident and sickness insurance agents, in Canada, which now increasingly focuses on proactive rather than reactive supervision. 4.1.1 Provincial and territorial regulatory authorities. The federal, provincial and territorial governments legislate and enact regulations for insurance companies. However, federal supervision under the Insurance Companies Act, as well as by the Office of the Superintendent of Financial Institutions, OSFI, is primarily to determine the Financial soundness of the federally incorporated life insurance companies, while the provinces and territories are responsible not only to determine the financial soundness of the provincially or territorially incorporated life insurance companies, as the case may be, but also for licensing insurance agents and regulating the licensing of insurers operating within their jurisdictions as well as the marketing of insurance products. 195. The provinces and territories are also responsible for regulating market conduct. According to the Canadian Council of Insurance Regulators, CCIR, market conduct encompasses any product or service relationship between the insurance industry, insurers, agents and individuals alike, and the public. It is influenced by many factors including laws, established best practices, codes of conduct, and client expectations. 196. One priority is risk-based regulation, which directs the regulator's efforts toward issues which could have negative impacts on clients. The CCIR affirms that a risk-based approach could be used to focus regulatory attention on insurers where indicators suggest there is a high risk of non-compliance with the legislation, rather than giving every insurer equal weight and examining them all. 197. In other words, breaches of compliance systematically generate an increased supervision by regulators. Regulatory authorities have a mandate to ensure fair, responsible and professional conduct by life insurance agents. They fulfill their mandate by setting expectations and requirements for regulating the conduct of life insurance agents toward clients, including Black Small Square promoting transparency to clients, Black Small Square taking enforcement actions against breaches of conduct, Black Small Square equipping clients with financial knowledge and skills, understanding financial concepts and terminology, Black Small Square giving clients access to independent complaint resolution avenues, such as the Ombuds Service for life and health insurance. 4.1.2 Provincial and territorial insurance regulators. There are 10 provincial and 3 territorial regulators responsible for the regulation of agents and agencies. 198. As mentioned previously, OSFI is not responsible for the licensing, regulating and supervision of an insurance agent's practice. 4.1.2.1 British Columbia. In British Columbia, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Insurance Council of British Columbia, 199, while the British Columbia Financial Services Authority, BCFSA, 200 issues business authorization to insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Financial Institutions Act, 201, the rules of the Insurance Council of British Columbia, 202, and the Code of Conduct of the Insurance Council of British Columbia. 203. There is no specific chapter regarding agents in the Insurance Act. 204. However, the Financial Institutions Act contains certain relevant provisions relating to insurance agents. 4.1.2.2 Alberta. In Alberta, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Alberta Insurance Council, part of the Alberta Treasury Board and Finance. Financial Sector, Regulation and Policy, 206, while the Office of the Superintendent of Insurance of Alberta 207 licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 208 and the Life Insurance Council Code of Conduct. 209. 4.1.2.3 Saskatchewan. In Saskatchewan, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Life Insurance Council of Saskatchewan, 210, while the Financial and Consumer Affairs Authority of Saskatchewan, Insurance and Real Estate Division, 211 licenses the insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Saskatchewan Insurance Act 212, the Life Insurance Council Guidance Notes 213 and the Life Insurance Council Bylaws. 214. Please note that on January 1, 2020, the Saskatchewan Insurance Act was replaced by the Insurance Act. 215. You will find a Schedule 3 that you may use as a table of concordance between the relevant sections of the Saskatchewan Insurance Act and the Insurance Act. In Saskatchewan, in order to be allowed to distribute segregated funds, a life insurance agent must have completed a course recognized by the Life Insurance Council of Saskatchewan. The passing of all four LLQP modules is an approved course. If a life insurance agent is not allowed to sell segregated funds, a restriction will appear on his license. 216. It is important to note that the Managing General Agent, MGA, and the Third-Party Administrator, TPA, licenses also exist in Saskatchewan. 217. 4.1.2.4 Manitoba. In Manitoba, life insurance agents and accident and sickness insurance agents are licensed by the Insurance Council of Manitoba, 218, while the Manitoba Financial Services Agency, Financial Institutions Regulation Branch, FIRB, 219 licenses the insurance companies. There is no license for corporate agencies. However, it is possible to find an agent through an agency search. 220. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 221, the Insurance Agents and Adjusters Regulation 389/87, the Life Insurance Agents and Accident and Sickness Insurance Agents Licensing Rules and by the Life Insurance and Accident and Sickness Agents Code of Conduct. 222. 4.1.2.5 Ontario. In Ontario, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Financial Services Regulatory Authority of Ontario, FSRA, in replacement of the Financial Services Commission of Ontario, FSCO, 223, which also regulates insurers. That replacement occurred on June 8, 2019. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act 224 and by the Agents Regulation 225, the replacement of Life Insurance Contracts Regulation 226. The Unfair or Deceptive Acts or Practices Regulation 227, the Variable Insurance Contracts Regulation 228, the Administrative Penalties Regulation 229, and the Code of Ethics for Life Insurance Agents in Ontario, which does not have legal effects, unlike the Code of Conducts in British Columbia, Alberta and Manitoba. 230. Other regulations have come into force on July 1, 2016. 231. 4.1.2.6 Quebec. In Quebec, life insurance agents, accident and sickness insurance agents, insurance brokers and independent agencies are licensed by the Autorité des Marchés Financiers, AMF, 232, which also regulates insurers. However, the discipline of life insurance agents and accident and sickness insurance agents is the Responsibility of the Chambre de la Sécurité Financière, CSF, while the AMF is responsible for the supervision and discipline of corporate agencies, firms and independent partnerships. Point 233. Life insurance agents and accident and sickness insurance agents are governed by an act respecting the distribution of financial products and services, 234, by the regulation respecting firms, independent representatives and independent partnerships, 235, the Code of Ethics of the Chambre de la Sécurité Financière, 236, the regulation respecting the issuance and renewal of representatives certificates, 237, the regulation respecting the pursuit of activities as a representative, 238, the regulation of the Chambre de la Sécurité Financière respecting compulsory professional development, 239, the regulation respecting the registration of firms, representatives and independent partnerships, 240. The regulation respecting information to be provided to consumers, 241, and the regulation respecting the keeping and preservation of books and registers. Point 242. 4.1.2.7 New Brunswick. In New Brunswick, life insurance agents and accident and sickness insurance agents are licensed by the Financial and Consumer Services Commission, FCNB, 243, which also licenses insurance companies. License for corporate agencies and managing general agents, MGAs, are now required. 244. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. Point 245. 4.1.2.8 Nova Scotia. In Nova Scotia, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Office of the Superintendent of Insurance, part of the Nova Scotia Department of Finance and Treasury Board, Office of the Financial Institutions Division, 246, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. Point 247. 4.1.2.9 Prince Edward Island. In Prince Edward Island, life insurance agents and accident and sickness insurance agents are licensed by the Prince Edward Island Superintendent of Insurance, part of Justice and Public Safety, Consumer, Corporate and Financial Services Division, 248, which also licenses insurance companies. There is no license for corporate agencies. Non-resident corporate agencies are required to register under the Extra-Provincial Corporations Registration Act, RSPEI 1988, CE 13. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 4.1.2.10 Newfoundland and Labrador. In Newfoundland and Labrador, life insurance agents, accident and sickness insurance agents and corporate agencies are licensed by the Superintendent of Insurance, part of Service NL, Financial Services Regulation Division, 250, which also licenses insurance companies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Adjusters, Agents and Brokers Act. Point 251 The Insurance Companies Act 252, the Insurance Contracts Act 253, the Life Insurance Act 254 and the Accident and Sickness Insurance Act 255 are equally relevant. 4.1.2.11 Yukon. In Yukon, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, Department of Community Services, Professional Licenses and Regulatory Affairs Branch, 256, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 257. 4.1.2.12 Northwest Territories. In the Northwest Territories, life insurance agents and accident and sickness insurance agents are licensed by the Office of the Superintendent of Insurance, part of Finance, which also licenses insurance companies. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 258. 4.1.2.13 Nunavut. Since April 1, 2013, the Government of Nunavut administers its powers under the Insurance Act itself. This is done through the Office of the Superintendent of Insurance of Nunavut, part of Finance. Prior to that date, the Nunavut Insurance Act was administered by the Office of the Superintendent of Insurance of the Northwest Territories. There is no license for corporate agencies. Life insurance agents and accident and sickness insurance agents are governed by the Insurance Act. 260. 4.1.3 Canadian Insurance Services Regulatory Organizations, CISRO. The Canadian Insurance Services Regulatory Organizations, CISRO, defines itself as an interjurisdictional group of regulating authorities who are dedicated to developing consistent standards of qualifications and practice for insurance intermediaries dealing in insurance of persons and property. 261. The principal responsibility of the members of CISRO is to administer the regulatory system applicable to insurance intermediaries, under their authority. Although CISRO members cannot enact legislation, they are key advisors to their governments on regulatory issues related to insurance intermediaries. The CISRO website includes a link to disciplinary actions taken by insurance regulators. This provides transparency to both the industry and clients. 262 The regulatory authorities also work with other authorities and agencies through the Joint Forum of Financial Market Regulators, and maintain constructive dialogue with client associations on issues confronting the life insurance buying public. In September 2018, CISRO, in collaboration with CCIR, has published a guidance entitled Conduct of Insurance Business and Fair Treatment of Customers, which applies to insurers as well as insurance intermediaries, individual agents, brokers and representatives. According to the guidance, fair treatment of customers encompasses concepts such as ethical behavior, acting in good faith, and the prohibition of abusive practices. Ensuring fair treatment of customers encompasses achieving outcomes such as black small square developing, marketing and selling products in a way that puts customers' interests ahead of their own. Black small square providing customers with accurate, clear, not misleading and sufficient information before, during, and after the point of sale, which will allow him to make informed decisions. Black small square minimizing the risk of sales which are not appropriate to the customer's needs. Black small square ensuring that any advice given is relevant. Black small square dealing with customer claims, complaints and disputes in a fair and timely manner. Black small square protecting the privacy of customer information. 4.1.4 Other authorities providing client protection. There are a number of other authorities that protect the client. Those most relevant to the activities of a life insurance agent are discussed below in the following order. Black small square Office of the Privacy Commissioner of Canada. Black Small Square Financial Transactions and Reports Analysis Centre of Canada, FINTRAC. Black Small Square Assuries. Black Small Square Ombud Service for Life and Health Insurance, OLHI. Black Small Square Canadian Council of Insurance Regulators, CCIR. 4.1.4.1 Office of the Privacy Commissioner of Canada. The mandate and mission of the Office of the Privacy Commissioner of Canada is to administer enforcement of the Federal Personal Information Protection and Electronic Documents Act, PIPEDA, Canada's private sector privacy legislation, and to protect and promote the privacy rights of individuals. 263. Life insurance agents operating in British Columbia, Alberta and Quebec are subject to their own province's Personal Information Protection Act. Agents should recognize that they have a responsibility to keep client information confidential and to secure that information. 264. Example. Nancy, a licensed life insurance agent in Manitoba, kept her client files in an unlocked cabinet in her office or on her computer, which had her password taped to the keyboard. Her office was broken into, her files rifled and her computer stolen. Nancy did not comply with PIPEDA. She should have made sure the files were kept in a secure place. 4.1.4.2 Financial Transactions and Reports Analyses Centre of Canada, FINTRAC. The Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, Canada's Financial Intelligence Unit, was created in 2000. It is an independent agency, reporting to the Minister of Finance, who is accountable to Parliament for the activities of the Centre. It was established and operates within the ambit of the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCMLTFA, and its regulations. FINTRAC's mandate is to facilitate the detection, prevention and deterrence of money laundering and the financing of terrorist activities, while ensuring the protection of personal information under its control. It fulfills its mandate through the following activities. Black Small Square receiving financial transaction reports in accordance with the PCMLTFA and regulations and safeguarding personal information under its control. Black Small Square ensuring compliance of reporting entities with the PCMLTFA and regulations. Black Small Square producing financial intelligence relevant to investigations on money laundering, terrorist activity, financing and threats to the security of Canada. Black Small Square researching and analyzing data from a variety of information sources that shed light on trends and patterns in money laundering and terrorist financing. Black Small Square maintaining a registry of money services businesses in Canada, and Black Small Square enhancing public awareness and understanding of money laundering and terrorist activity. Financing. 265. In general, an insurance of persons representative who offers products on behalf of a single insurer acts as mandatory of that insurer. A representative who acts on behalf of several insurers is the mandatory of one of them when he carries out acts on behalf of that insurer. Such acts may be one of those described below. When ascertaining the client's identity, the Proceeds of Crime, Money Laundering, and Terrorist Financing Act 266 is important. Its purpose is to detect individuals and companies involved in criminal activities, and to deter money laundering. Insurance representatives are part of the process, because permanent and universal life insurance products as well as non-registered annuity contracts can be used as a means to create, accumulate and transfer wealth. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the Act, introduces mechanisms to ensure that the right person or entity is dealt with, to identify individuals and entities taking part in criminal activities and to discourage money laundering. An insurance of persons representative has specific obligations under the Act and its regulations in order to help combat money laundering and terrorist financing in Canada. The representative is required to verify the identity of any person or entity, hereinafter, the client, or the beneficiary, for whom an information record is kept regarding the sale of an immediate or deferred annuity or a life insurance policy. Black small square for which the client may pay $10,000 or more over the duration of the annuity or policy. Black small square for which a beneficiary may receive $10,000 or more over the duration of the annuity or policy. FINTRAC defines beneficiary as the individual or entity that will benefit from a transaction or to which the final remittance is made. 267 This very broad definition covers any annuity payment or surrender transaction, in addition to death benefit payments. The representative must therefore, on the one hand, verify the client's identity in connection with the sale, if the client may pay $10,000 or more over the duration of the annuity or policy. On the other hand, he must verify the identity of the beneficiary indicated in the information record before the first payment is made to the beneficiary, if that beneficiary may receive $10,000 or more over the duration of the annuity or policy. In all cases, the identity must be verified within 30 days of the creation of the information record, regardless of the means of payment. The representative must at all times record the required information in the client's file. 268. Moreover, an identity need not be verified again if black small square the identity of an individual has already been verified or the existence of an entity has already been confirmed using a method permitted by the Act and its regulations. Permitted methods are discussed later. Black small square the required documents are kept on file, and black small square no doubt remains as to the information obtained. Specific exceptions apply to the identity verification obligation. For example, an insurance of person's representative is not required to verify the identity of a person or confirm the existence of an entity at the time of purchase of a registered individual or group annuity contract, RRSP, RRIF. LIRA, LIF, DPSP, RPP, TFSA, etc., exempt life insurance contract, 269 and accident and sickness insurance contract without a cash surrender value. However, in some circumstances, an identity verification may nevertheless be required by the insurer for exempt plans or products. Where applicable, an identity verification allows the insurer to confirm the client's age or comply with its obligations under the Foreign Account Tax Compliance Act, FATCA, 270 and the Common Reporting Standard 271, Parts 18 and 19 of the Federal Income Tax Act, two international initiatives aimed at countering tax evasion by citizens or residents of other countries with accounts in Canada, and vice versa. For non-exempt insurance and annuity contracts, the insurance of persons representative is required to verify the client's or beneficiary's identity using one of the methods permitted by the Act and its regulations. The representative must do so for each policyholder or owner, including any co-policyholders, and for each beneficiary. Under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, the representative is required to properly verify the client's identity. Methods to verify the identity of persons and entities, 272. FINTRAC describes 5 methods to verify the identity of a person or an entity. 273. The approach depends on the type of client or beneficiary, individual, corporation or other entity, and the context. In the client's or beneficiary's presence or absence, 274. 1. Government-issued photo identification method. White small square. The identification document must show the individual's name and contain the individual's photo. The document must be valid, current and original. White small square. The document must contain a unique identification number. White small square. The name and photo on the document must match the name and appearance of the person being verified. Some examples include a Canadian passport, a permanent resident card, a secure certificate of Indian status, a driver's license, and provincial or territorial identification cards. In Quebec, an insurance representative cannot ask to see a person's health insurance card, but can accept it if that person presents it for identification purposes. In Ontario, Manitoba, Nova Scotia or Prince Edward Island, such use is prohibited. A social insurance card may not be used to verify identity, and a social insurance number, SIN, may not be used in a report made to FINTRAC.275. A SIN is used for tax purposes only and is required to that end in some types of insurance of persons contracts. When verifying someone's identity based on a piece of photo identification, a representative must obtain and record the following information. Black small square. The name on the photo identification. Black small square. The type of photo identification used. Black small square. The photo identification reference number. Black small square. The place the photo identification was issued. And black small square. The expiry date of the photo identification. 2. Credit file method. A credit file is used as an identification method to verify the identity of a person who is not physically present. This method requires that consent first be obtained from the client or beneficiary before consulting the information contained in the credit file. A specific independent identification product is then used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada. It is important to note that Canadian credit bureaus offer independent identification products that can be used to consult a credit file for identity verification purposes without affecting a person's credit score. To use the credit file identification method, the search has to be performed at the same time as the identity verification. A credit file cannot be used if it was obtained at an earlier date or if a copy was provided by the person to whom the file applies. The search results must meet the following criteria. Black small square. The client's or beneficiary's credit file must have at least 3 years of history and must contain valid and current information. Black small square. The name, address and date of birth in the credit file must be the same as those provided by the client or beneficiary. Black small square. The credit file must be Canadian, as foreign credit files are not accepted, and the information in the credit file must be derived from more than one source, i.e., from more than one trade lane. The copy of the search results from Canadian Credit Bureau databases must be kept in the client file, the report produced by the Canadian Credit Bureau, and must contain the following. Black small square. The source of the credit file, for example, the name and logo of the credit bureau. Black small square. The name of the person whose identity is being verified. black small square the credit file reference number, and black small square the date the credit file was consulted. Where a Canadian credit bureau cannot authenticate even just one item of information on the client or beneficiary, for example, if the first name, last name, date of birth or address does not match, or if the credit file is not Canadian, has less than 3 years of history or is derived from a single source, a single trade lane, the credit file method alone cannot be used. At this point, another method must be used to verify the client's or beneficiary's identity. 3. Dual process method. The dual process identification method is used to verify the identity of a person that is not physically present. It requires performing two actions, consulting two independent credit transactions or referring to two reliable and distinct sources to verify a client's or beneficiary's identity. On the one hand, a specific independent identification product can be used to search the databases of a Canadian credit bureau, for example, Equifax Canada or TransUnion Canada. As the aggregator, to compile information from two independent credit transactions dating back at least 6 months. The client's or beneficiary's consent must have been obtained first. These two credit transactions must have been carried out by the client or beneficiary with two independent and distinct business sources and must have two of the following three matches. Black small square the client's or beneficiary's name and address. Black small square the client's or beneficiary's name and date of birth, and/or black small square the name and existence of a financial account in the client's or beneficiary's name with a financial institution. Where a Canadian credit bureau cannot make two of the three matches mentioned above using two independent credit transactions dating back at least 6 months, another solution must then be used to verify the client's or beneficiary's identity. Various combinations are possible. Below are two examples. Black small square an analysis of the search results from Canadian Credit Bureau databases yields a first match from among the ones mentioned above. For example, the Canadian Credit Bureau matched and confirmed the name and date of birth of the client or beneficiary, and the verification of a document from a reliable source yields a second match, for example, a statement issued by a Canadian federal government agency confirms the name and address of the client or beneficiary, or black small square an analysis of the search results reveals that the Canadian Credit Bureau was unable to obtain any of the three matches mentioned above, in which case the representative must refer to information from two reliable and distinct sources, such as white small square a statement issued by a Canadian federal government agency to confirm the person's name and address, first match, and white small square a deposit account statement confirming the person's name and the fact that he holds a deposit account in a financial entity, second match. The information obtained must be valid and current and must be derived from different reliable sources. 276 examples include statements, letters, certificates, forms and other admissible and reliable information sources. 277. In all cases, the information provided by the client, first and last name, address and date of birth, must be the same as those obtained from the Canadian Credit Bureau or derived from reliable and distinct sources. The following details must be recorded. Black small square the name of the person whose identity is being verified. Black small square the date the information was consulted. Black small square the name of the two different sources used to verify the person's identity. Black small square the type of information used, for example, a utility account statement, bank statement or marriage certificate. Black small square the number associated with the information, for example, the account number or reference number, and black small square the account number associated with each trade lane for information aggregated by a Canadian credit bureau. 4. Affiliate or member method. The identity of a person or an entity can be verified by confirming that one of the following entities has previously performed such a verification. Black small square an affiliate that is one of the following reporting entities: res, bank, foreign bank, cooperative, credit society, savings and credit union, caisse populaire, life company, foreign life company, trust company, loan company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities or any other financial instruments or to provide portfolio management or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity. An affiliate carrying out outside of Canada activities similar to those listed above. Black small square a financial entity subject to the proceeds of crime, money laundering, and terrorist financing act and member of the Financial Services Cooperative or Credit Unions Central of the Insurance of Persons representative carrying out the verification. The name, address and date of birth in the records of the affiliate or the member financial entity must match the information provided by the person whose identity is being verified. For a corporation or other entity, the records of the affiliate or member financial entity must state that an admissible document was used and retained to confirm its existence and that its name, its address, and the names of its directors were verified and recorded. The affiliate or member financial entity must have previously verified. Black small square the identity of the person using the government-issued photo identification method, credit file method or dual process method described earlier, or black small square the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the affiliate or member financial entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the proceeds of crime, money laundering, and terrorist financing regulations using the methods in place at the time of the verification. When an affiliate or a member financial entity has previously verified a person's identity, the following information must be recorded. Black small square the name of the person or entity whose identity was verified. Black small square the date the identity was verified. Black small square the name of the affiliate or member financial entity that verified the person's or entity's identity. Black small square the method used to verify the person's or entity's identity, and black small square the information and or documents recorded by the affiliate or member financial entity according to the method used, including the date the identity was verified by the affiliate or member financial entity. 5. Reliance method. A person's or entity's identity can be verified by relying on the measures already taken by black small square another from among the following: bank, foreign bank, cooperative credit society, savings and credit union, caisse populaire, life company, foreign life company, trust company, loan company, or a person or entity authorized under provincial legislation to engage in the business of dealing in securities or any other financial instruments or to provide portfolio management or investment advising services, other than persons who act exclusively on behalf of such an authorized person or entity, or black small square an entity that is affiliated with the insurance of persons representative, or with another and carries out activities outside of Canada that are similar to those listed above, i.e., an affiliated foreign entity. When another RE or an affiliated foreign entity has previously verified a person's or entity's identity, the information recorded and the documents required must be promptly obtained from the other RE or affiliated foreign entity. This information and documents must be valid and current and must match those provided by the person or entity whose identity is being verified. The other RE or affiliated foreign entity must have previously verified the identity of the person using the government-issued photo identification method, credit file method or dual process method described earlier, or the identity of the corporation or other entity using the confirmation of existence method. This method is discussed in detail later. If the other RE or affiliated foreign entity verified the person's or entity's identity prior to June 1, 2021, it must have done so pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations using the methods in place at the time of the verification. In addition, the other RE or affiliated foreign entity must have had a written agreement or arrangement that requires all of the information it had referred to in order to verify the person's identity to be provided as soon as feasible upon request. Using a mandatory to verify the identity of a person. The insurance of person's representative can use a mandatory acting on his behalf to verify the identity of a person. A written agreement must previously have been reached with the mandatory. To this effect, the representative remains responsible for the identity verification under the Act and its regulations, even though this task is entrusted to the mandatory. Any mandatory who verifies a person's identity on behalf of a representative must use the government-issued photo identification method, credit file method or dual process method described earlier. Satisfy the current requirements for each of these methods, and record the required information. If the mandatory verified the person's identity prior to June 1, 2021, he must have done so pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing regulations using the methods in place at the time of the verification. The information obtained must meet the criteria for verifying the person's identity. Verifying the identity of a corporation or other entity. To verify the identity of a corporation, an insurance of persons representative must consult one of the following documents. A certificate of incorporation. A record that the corporation has to file annually under provincial securities legislation, or the most recent version of any other record that confirms the corporation's existence and contains its name and address and the names of its directors, SUWWCH as a certificate of active corporate status, the corporation's annual report signed by an audit firm, or a letter or notice of assessment for the corporation from a municipal, provincial, territorial or federal government. The record used must be authentic, valid and current. The insurance of persons representative must obtain the corporation's name and address and the names of its directors. To do this, a search may be performed in a provincial database, such as that of the Registre des Entreprises du Québec, or federal database, such as the Corporations Canada database. The insurance of persons representative can also obtain this type of information by subscribing to an online corporation search and registration service. To verify the identity of an entity other than a corporation, the insurance of persons representative may use a partnership agreement. black small square articles of association, or black small square, the most recent version of any other similar record that confirms its existence and contains its name and address. To verify the identity of a trust, the insurance of persons representative may use the deed of trust. Or, in the case of a testamentary trust, the will. To verify the identity of a succession, the insurance of persons representative may use a copy of the death certificate and the last will and testament of the deceased person. The record used must be authentic, valid and current. If the insurance of persons representative consults a paper or an electronic record, he must keep that record or a copy of it. If the insurance of persons representative consults the electronic version of a record from a database accessible to the public, he must keep a record that includes the corporation's or other entity's registration number, the type of record consulted and the source of the electronic version of the record. Signing authority resolution, corporations. When the client or beneficiary is a corporation, the insurance of persons representative must obtain a signing authority resolution clearly designating the individuals duly authorized to act and sign on behalf of the corporation. This record derives from the corporation's official registers and must be signed by all board of directors members entitled to vote on this resolution. Examples of documents to be used as a resolution include the certificate of incumbency, meeting minutes and the corporation's bylaws. A corporation is a legal entity separate from its shareholders. It may be incorporated under provincial or federal legislation and usually has a permanent existence, until its dissolution. Its aim is to operate an enterprise for the purpose of generating profit that will be distributed, as applicable, among its shareholders. Information on the ownership, control and structure of entities. The insurance of persons representative must obtain information describing the ownership, control, and structure of entities. Black small square corporation. The names of all its directors and the names and addresses of all its beneficial owners. Black small square trust. The names and addresses of all trustees, known beneficiaries and known settlers of the trust. Black small square widely held or publicly traded trust. The names and addresses of all trustees and the names and addresses of all beneficial owners. Black small square succession. The names and addresses of all liquidators or individuals who have control over the succession. Black small square other entity. The names and addresses of the beneficial owners. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the information obtained and must keep the records in which the required information appears when that information is first obtained and in the course of conducting ongoing monitoring of business relationships. Verification of beneficial owners 279. The insurance of persons representative must obtain the required information on beneficial owners. Pursuant to the Proceeds of Crime, Money Laundering, and Terrorist Financing Regulations. Beneficial owners are the individuals who directly or indirectly own or control 25% or more of a corporation or an entity other than a corporation. In the case of a corporation, the beneficial owners are often its shareholders. In the case of a trust, they are the trustees, the known beneficiaries and the settlers of the trust. In the case of a widely held or publicly traded trust, they are all of its trustees as well as all persons who directly or indirectly hold or control 25% or more of its units. In the case of a succession, they are its liquidators. Beneficial owners cannot be other corporations, trusts or other entities. They must be the individuals who are the owners or controllers of the entity. It is necessary to search through all the possible layers of information of the chain of control of the corporation or other entity in order to determine the beneficial owners. It is important to consider and review the names found in the corporate, government or legal documents consulted in order to make certain that they match the names of the individuals who have actual ultimate control of the corporation or other entity. The insurance of persons representative must also take reasonable measures to confirm the accuracy of the beneficial ownership information when that information is first obtained and in the course of conducting ongoing monitoring. 280 of Business Relationships. Point 281. Third-party determination requirements. A third party is the person or entity that instructs another person or entity to conduct an activity or financial transaction on their behalf. As such, the third party is the instructing party as to the handling of the money or the performance of the transaction or activity in particular, and is also understood to be the on behalf of party. The insurance of persons representative must take reasonable measures to determine whether a third party is involved when a transaction or activity is carried out. This verification is carried out in order to identify a person or an entity that takes part in criminal activities relating to money laundering and terrorist activity financing, and that has another person or entity carry out a financial transaction in its place. Reasonable measures for third-party determination include asking the client if they're acting at the instruction of another person or entity, or asking whether another person or entity will be instructing on the account. The reasonable measures the insurance of persons representative takes to make a third-party determination must be documented in his compliance programs, policies and procedures. The insurance of persons representative must take reasonable measures to make a third-party determination when he is required to black small square report a large cash transaction or keep a large cash transaction record. 282. Black small square report a large virtual currency transaction or keep a large virtual currency (VC) transaction record. 283. Black small square keep an information record. Point 284. With regard to this last point, the reasonable measures for third-party determination must be taken when the information record is created. However, some circumstances may subsequently arise, requiring another third-party determination. This occurs, for example, when a mandate in anticipation of incapacity becomes enforceable, or when a new person or entity provides instructions regarding the annuity or life insurance policy. If the insurance of persons representative determines that a third party is involved, he must take reasonable measures to obtain the following information on the third party. Black small square if the third party is a person. Their name, address, telephone number, not required if the third party determination is made for a large cash transaction or large VC transaction, date of birth and occupation, or, in the case of a sole proprietor, the nature of their principal business. Black small square if the third party is a corporation or other entity. Its name, address, telephone number, not required. If the third-party determination is made for a large cash transaction or large VC transaction, the nature of its principal business, its registration or incorporation number, and the jurisdiction of issue of that number. Black small square the relationship between the third party and the following person or entity, as applicable. White small square the person who conducts the large cash transaction. White small square the person who conducts the large VC transaction. White small square the person or entity that the information record is kept on. Regarding this last point, the relationship between the person or entity and the third party can be, for example, that of an accountant, a broker, a customer, an employee, a friend or a relative. A third-party determination should also be made when the person or entity making an annuity or life insurance policy payment is not the person or entity on whom the information record is kept. The purpose of this verification is to identify ploys aimed at concealing, or making it difficult to trace, the origin of sums derived from criminal activity. There is an exception to third-party determination whereby an insurance of persons representative does not need to make a third-party determination when he keeps an information record on a beneficiary in connection with the sale of a life insurance policy under which he is to remit an amount of $10,000 or more to the beneficiary over the duration of the policy, regardless of the means of payment. Politically exposed person, PEP, and head of international organization, HIO, determination. PEPs and HIOs are entrusted with a prominent position that typically comes with extensive access to considerable resources and the opportunity to influence decisions. The access, influence and control that PEPs and HIOs have can make them vulnerable to corruption and the potential targets of criminals who could exploit their status and use them, knowingly or unknowingly, to carry out money laundering or terrorist activity financing offenses. The family members and close associates of PEPs and HIOs are potential targets as well because they can more easily avoid detection. References to PEPs include both foreign and domestic PEPs. A foreign PEP is a person 285 who holds or has held one of the following offices or positions in or on behalf of a foreign state. Black small square head of state or head of government. Black small square member of the Executive Council of Government or member of a legislature. Black small square deputy minister or equivalent rank. Black small square ambassador, or attaché or counselor of an ambassador. Black small square military officer with a rank of general or above. Black small square president of a state-owned company or a state-owned bank. Black small square head of a government agency. Black small square judge of a Supreme Court, Constitutional Court or other court of last resort, or black small square leader or president of a political party represented in a legislature. These persons are foreign PEPs regardless of citizenship, residence status or birthplace. Foreign PEP status is permanent. A domestic PEP is a person 286 who currently holds, or has held within the last 5 years, one of the following offices or positions in or on behalf of the Canadian federal government, a Canadian provincial, or territorial, government, or a Canadian municipal government. Black small square Governor-General, Lieutenant Governor or Head of Government. Black small square member of the Senate or House of Commons or member of a legislature. Black small square Deputy Minister or equivalent rank. Black small square ambassador, or attaché or counselor of an ambassador. Black small square military officer with a rank of general or above. Black small square president of a corporation that is wholly owned directly by Her Majesty in right of Canada or a province. Black small square head of a government agency. Black small square judge of an appellate court in a province, the Federal Court of Appeal or the Supreme Court of Canada. Black small square leader or president of a political party represented in a legislature, or black small square mayor of a city, town, village and rural, county, or metropolitan municipality, regardless of population size. A person ceases to be a domestic PEP 5 years after leaving office. A HIO is a person 287 who currently holds or has held within the last 5 years one of the following offices or positions. Black small square head of an international organization established by the governments of states, or black small square head of an institution established by an international organization. When we refer to the head of an international organization or the head of an institution established by an international organization, we are referring to the primary person who leads that organization, for example, a president or CEO. There is no requirement for an institution established by an international organization to operate internationally. It is possible for it to operate only domestically or in one jurisdiction. A person ceases to be a HIO 5 years after leaving office. If a person is a PEP or a HIO, certain members of their family must also be considered PEPs or HIOs under the Act and its regulations. These family members are black small square their spouse or common law partner, black small square their biological or adoptive child or children, black small square their mothers or fathers, black small square the mothers or fathers of their spouse or common law partner, mother-in-law or father-in-law, and black small square a child, children, of their mother or father, sibling. A close associate can be an individual who is closely connected to a PEP or HIO for personal or business reasons. Some examples of a close association for personal or business reasons include, but are not limited to, a person who is white small square business partners with, or who beneficially owns or controls, directly or indirectly, a business with, a PEP or HIO. Black small square in a romantic relationship with a PEP or HIO. Black small square involved in financial transactions with a PEP or HIO. Black small square a prominent member of the same political party or union as a PEP or HIO. Black small square serving as a member of the same board as a PEP or HIO. Black small square closely carrying out charitable works with a PEP or HIO. Or black small square the owner of a joint insurance policy with a PEP or HIO. The insurance of persons representative must take reasonable measures to determine whether a person is a PEP, HIO or family member or close associate of a PEP or HIO with respect to the following transactions. Black small square receipt of a lump sum payment in the amount of $100,000 or more in funds or an amount of VC equivalent to $100,000 or more in respect of an immediate or deferred annuity or a life insurance policy, and black small square remittance of an amount of $100,000 or more in funds or an amount of VC equivalent to $100,000 or more to a beneficiary over the duration of an immediate or deferred annuity or of a life insurance policy. Some exceptions are described on the FINTRAC website. When the representative determines that a person is a foreign PEP or a family member or close associate of a foreign PEP, he must consider there to be a high risk of a money laundering, ML, or terrorist activity financing, TF, offense being committed. Specific obligations apply to keeping records, establishing the source of the funds or VC used for the transaction, establishing the source of the foreign PEP's personal wealth and having the transaction reviewed by a member of senior management. When the representative determines that a person is a domestic PEP or HIO or a family member or close associate of a domestic PEP or HIO, he must finish the risk assessment 289 to determine whether a high risk of an ML or TF offense being committed exists. If the risk level is considered high, specific obligations apply to keeping records, establishing the source of the funds or VC used For the transaction, establishing the source of the domestic PEP's or HIO's personal wealth and having the transaction reviewed by a member of senior management. A member of senior management is a person who has the authority to make management decisions about transactions or accounts and is accountable for them. Awareness of the ML or TF risks to which the representative is exposed, and awareness and understanding of the representative's obligations related to PEPs, HIOs and their family members and close associates. If the insurance of persons representative is a sole proprietor with no employees, agents or other persons authorized to act on his behalf, he is considered to be the senior manager. The insurance of persons representative must keep a record of the office or position and the name of the organization or institution of the PEP or HIO. The date of the determination. The source of the funds or VC used for a lump sum payment or received from the annuitant of an immediate or deferred annuity or the holder of a life insurance policy, if known. The source of the person's wealth, if known. The name of the member of senior management who reviewed the transaction, and the date of that review. The representative can also include a record describing the nature of the relationship between a family member or close associate and the PEP or HIO, as applicable. Verifying the identity of a corporation or other entity. Obligation to report suspicious transactions to FINTRAC 290. A suspicious transaction is a transaction or attempted transaction giving reasonable grounds to suspect that it is related to a ML or TF offense, whether or not it has been completed. In general, a transaction could be related to a ML or TF offense if it, or a series of transactions, raises questions or causes doubt, concern or mistrust. There is no threshold or minimum amount for reporting a suspicious transaction. In addition to identifying suspicious transactions, the insurance of persons representative must also acknowledge the presence of ML or TF indicators. ML or TF indicators are potential warning signs likely to trigger suspicions or indicate that something is unusual in the absence of a reasonable explanation. These signs generally stem from one or more facts, behaviors, models or other contextual aspects that reveal irregularities in transactions. A single indicator, in and of itself, might not be or appear suspicious, whereas in a given context, one or more indicators could arouse suspicion or cause unease. Below are a few examples. The client refuses to produce the required personal identification documents, wants to establish his identity through means other than his personal identification document or inordinately delays in presenting his corporate documents. The client is accompanied and watched, secretive, nervous or overjustifies himself. The client displays uncommon curiosity about internal controls or unusual knowledge about legislation regarding suspicious transaction reporting. The client deposits large third-party checks. The client shows more interest in the cancellation than in the long-term benefits of the product. The transaction is unnecessarily complex for its stated purpose. The transaction seems to be inconsistent with the client's apparent financial situation or usual pattern of activities, or the client gives a post office box address rather than the street address of a residence. The representative must have the means to detect, analyze, document and report suspicious Transactions and attempted transactions. This includes black small square documenting the completed analysis and its result, including the evaluation of the facts and context surrounding the suspicious transaction, as well as the explanation of the link between this evaluation and the ML and TF indicators observed and the grounds for suspicion noted. Black small square taking reasonable measures to verify the client's or beneficiary's identity, if not already done. Black small square submitting the suspicious transaction report to FINTRAC as soon as practicable after having taken the measures described above to establish that reasonable grounds exist to suspect that the transaction or attempted transaction is linked to the commission of an ML or TF offense. The report must include white small square a description of the facts, the context, the ML and TF indicators observed, and the grounds for suspicion noted, as well as, where applicable, the suspected criminal offense related to ML or TF. White small square the reason the transaction or attempted transaction is linked to an ML or TF offense. White small square details of the completed analysis and its finding, in particular supporting the link between the ML and TF indicators observed, the grounds for suspicion noted and the finding of the analysis. Suspicious transaction reports are confidential. In addition, the insurance of persons representative must not disclose to the client or beneficiary that an analysis has been completed regarding a suspicious transaction or that a report has been made to FINTRAC. Failure to fulfill the obligation to report suspicious transactions may lead to financial, administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a suspicious transaction. Report to FINTRAC in good faith. Obligation to report terrorist property to FINTRAC. In Canada, Section 83.01 of the Criminal Code defines terrorist activity as an act committed, in whole or in part for a political, religious or ideological purpose, objective or cause, with the intention of intimidating the public, with regard to its security, including its economic security, or compelling a person, a government or a domestic or an international organization to do or to refrain from doing any act. Property is defined as anything owned or controlled by a person or entity, whether tangible or intangible. This includes black small square real and personal property, as well as deeds and instruments that give a title or right to property, or to receive money or goods, and black small square any property that has been converted or exchanged, or acquired from any conversion or exchange. The representative must have the means to detect, analyze, document and report suspicious transactions and attempted transactions. This includes black small square documenting the completed analysis and its result, including the evaluation of the facts and context surrounding the suspicious transaction, as well as the explanation of the link between this evaluation and the ML and TF indicators observed and the grounds for suspicion noted. Black small square taking reasonable measures to verify the client's or beneficiary's identity, if not already done. Black small square submitting the suspicious transaction report to FINTRAC as soon as practicable after having taken the measures described above to establish that reasonable grounds exist to suspect that the transaction or attempted transaction is linked to the commission of an ML or TF offense. The report must include white small square a description of the facts, the context, the ML and TF indicators observed, and the grounds for suspicion noted, as well as, where applicable, the suspected criminal offense related to. ML or TF. White small square the reason the transaction or attempted transaction is linked to an ML or TF offense. White small square details of the completed analysis and its finding, in particular supporting the link between the ML and TF indicators observed, the grounds for suspicion noted and the finding of the analysis. Suspicious transaction reports are confidential. In addition, the insurance of persons representative must not disclose to the client or beneficiary that an analysis has been completed regarding a suspicious transaction or that a report has been made to FINTRAC. Failure to fulfill the obligation to report suspicious transactions may lead to financial, administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a suspicious transaction. Report to FINTRAC in good faith. Obligation to report terrorist property to FINTRAC. In Canada, Section 83.01 of the Criminal Code defines terrorist activity as an act committed, in whole or in part for a political, religious or ideological purpose, objective or cause, with the intention of intimidating the public, with regard to its security, including its economic security, or compelling a person, a government or a domestic or an international organization to do or to refrain from doing any act. Property is defined as anything owned or controlled by a person or entity, whether tangible or intangible. This includes black small square real and personal property, as well as deeds and instruments that give a title or right to property, or to receive money or goods, and black small square any property that has been converted or exchanged, or acquired from any conversion or exchange. The representative must have the means to detect, analyze, document and report suspicious transactions and attempted transactions. This includes black small square documenting the completed analysis and its result, including the evaluation of the facts and context surrounding the suspicious transaction, as well as the explanation of the link between this evaluation and the ML and TF indicators observed and the grounds for suspicion noted. Black small square taking reasonable measures to verify the client's or beneficiary's identity, if not already done. Black small square submitting the suspicious transaction report to FINTRAC as soon as practicable after having taken the measures described above to establish that reasonable grounds exist to suspect that the transaction or attempted transaction is linked to the commission of an ML or TF offense. The report must include white small square a description of the facts, the context, the ML and TF indicators observed, and the grounds for suspicion noted, as well as, where applicable, the suspected criminal offense related to ML or TF. White small square the reason the transaction or attempted transaction is linked to an ML or TF offense. White small square details of the completed analysis and its finding, in particular supporting the link between the ML and TF indicators observed, the grounds for suspicion noted and the finding of the analysis. Suspicious transaction reports are confidential. In addition, the insurance of persons representative must not disclose to the client or beneficiary that an analysis has been completed regarding a suspicious transaction or that a report has been made to FINTRAC. Failure to fulfill the obligation to report suspicious transactions may lead to financial, administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a suspicious transaction. Report to FINTRAC in good faith. Obligation to report terrorist property to FINTRAC. In Canada, Section 83.01 of the Criminal Code defines terrorist activity as an act committed, in whole or in part for a political, religious or ideological purpose, objective or cause, with the intention of intimidating the public, with regard to its security, including its economic security, or compelling a person, a government or a domestic or an international organization to do or to refrain from doing any act. Property is defined as anything owned or controlled by a person or entity, whether tangible or intangible. This includes black small square real and personal property, as well as deeds and instruments that give a title or right to property, or to receive money or goods, and black small square any property that has been converted or exchanged, or acquired from any conversion or exchange. Examples of property include cash, monetary instruments, for example, checks, bank accounts, prepaid payment products, securities, jewelry, precious metals or precious stones, real estate, and insurance policies. Pursuant to subsection 83.01(1) of the Criminal Code, a terrorist group is defined as black small square an entity that has as one of its purposes or activities facilitating or carrying out any terrorist activity. Black small square a listed entity. 292 or black small square an association or group of such entities. The insurance of persons representative must fulfill the obligations under the Criminal Code and the regulations implementing the United Nations resolutions on the suppression of terrorism for reporting terrorist property to FINTRAC. On the one hand, the representative must have implemented documented measures and processes to check the list of his clients and identify any clients who appear on the official lists disseminated by Canadian oversight bodies. On the other hand, when the representative knows that property in his possession or available to him belongs to a terrorist or terrorist group, or is available to them, he must report it to FINTRAC as soon as possible. He must also submit a report to the Royal Canadian Mounted Police, RCMP, and the Canadian Security Intelligence Service, CSIS. At the same time, if FINTRAC determines that there are reasonable grounds to suspect that the information represents a threat to Canada's security, he can also forward the information to CSIS. Terrorist property reports differ from other reports submitted to FINTRAC because a transaction or attempted transaction need not have been completed for the representative to submit a report. It is the mere existence of property, such as a bank account, owned or controlled by or on behalf of a terrorist group or listed person that prompts the obligation to submit a report to FINTRAC. Terrorist property reports are confidential. In addition, the insurance of persons representative must not disclose to the client or beneficiary that an analysis has been completed regarding such property or that a report has been made to FINTRAC. Failure to fulfill the obligation to report terrorist property may lead to financial, administrative penalties and serious criminal sanctions. The representative is protected from legal proceedings when submitting a terrorist property report to FINTRAC in good faith. 292. The list of listed entities is available on the Public Safety Canada website. https://www.publicsafety.gc.ca/cnt/ntr-scrt/ntts/index-n.aspx 126. Ethics and Professional Practice. Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. It is important to note that the obligation to submit a terrorist property report does not exclude the obligation to submit a suspicious transaction report to FINTRAC if a transaction was completed or attempted and the representative has reasonable grounds to suspect that it is linked to the commission or attempted commission of an ML or TF offense. 293. Obligation to report large cash transactions to FINTRAC 294. It should be noted that insurers rarely accept cash payments. However, the insurance of persons representative must submit a large cash transaction report to FINTRAC if he receives black small square an amount of $10,000 or more in cash in the course of a single transaction, or black small square two or more amounts that total $10,000 or more within a consecutive 24-hour window made by or on behalf of the same individual or entity. He must submit the large cash transaction report to FINTRAC within 15 calendar days after the transaction. He does not have to make a large cash transaction report to FINTRAC if the cash is received from black small square a financial entity, bank, credit union, Caisse Populaire, etc., or black small square a public body or its agent, government department or ministry, hospital authority, etc. For more information on this topic, see Guideline 7, Submitting Large Cash Transaction Reports to FINTRAC. 295. Obligation to report large virtual currency, VC, transactions to FINTRAC 296. It is important to note that insurers rarely accept payments or transactions in VC. However, the insurance of persons representative must submit a large VC transaction report to FINTRAC if he receives black small square an amount in VC equivalent to $10,000 or more in a single transaction, or black small square two or more amounts in VC that total $10,000 or more within a consecutive 24-hour window and the transactions were conducted by the same person or entity, or were conducted on behalf of the same person or entity, or are for the same beneficiary. The representative must submit a large VC transaction report to FINTRAC within 5 working days after the day he receives the amount. For more information on this topic, see the FINTRAC Guideline on Reporting Large VC Transactions. 297. When information about the product is provided. When providing information about a product, insurers rely to a great extent on representatives to distribute their products and inform the public. The insurer's duty or obligation to inform is the cornerstone of a representative's responsibility. According to the Distribution Act, 298, a representative must describe the proposed products to the client in relation to the needs identified during the needs analysis and specify the nature of the coverage offered. He must clearly indicate to the client any particular exclusion of coverage and provide the client with an explanation. 299. He must also provide a disclosure document about the products. 300 where an insurance of persons representative sells an individual insurance of persons product or an individual annuity to a client. The representative must give the client, no later than on the date the policy is delivered, a legible document, in plain language, indicating the following. Black small square whether the insurance costs payable under the contract are guaranteed and, where applicable, for how long, and whether such amounts may fluctuate. Black small square whether the return on the amounts invested through the insurance product is guaranteed or not. Black small square whether the face amount of the insurance is guaranteed or may fluctuate. Black small square any specific exclusions contained in the contract. Black small square if a surrender fee or a penalty is payable if the contract is surrendered. This document, which is usually prepared by the insurer, can be an explanatory brochure about the product or an illustration. As regards individual variable insurance contracts, IVICs, pursuant to the AMF guideline on individual variable insurance contracts relating to segregated funds, the regulation respecting information to be provided to consumers 301 and CLHIA Guideline G2, individual variable insurance contracts relating to segregated funds, the insurance representative must give the client the following documents. Black small square the application form, proposal. Black small square the annuity contract. Black small square the information folder. Black small square the key facts, and black small square a fund facts summary. When the proposal is drawn up, an insurer must always be meticulous when drawing up an insurance proposal. It needs this document to make an informed decision as to whether or not to insure the risk related to the health or age of the insured. An insurance of persons representative must ask the questions exactly as they are drafted in the insurance proposal and refrain from interpreting them. He must provide the insurer with all the information given by the insured even if some of it seems unnecessary. The decision is up to the insurer, as it is the only one able to determine the importance to be given to the information provided. When an immediate or conditional cover note is given for certain life insurance products, an immediate or conditional cover note takes effect when the proposal is signed if certain conditions are met. The cover note will be in effect for a period which varies from one insurer to another. When this document is given, the insurance of persons representative must follow the insurer's instructions, because he is effectively binding the insurer. Generally, the insurer will authorize the insurance of persons representative to give a cover note only to those persons who, according to their answers to the questions asked, appear to be in good health. An insurance of persons representative does not have the authority to change the terms of a cover note upon payment of a sum of money. Section 102 of the Distribution Act states that any insurance premium paid to a firm or to one of its representatives for the account of an insurer is deemed to have been paid directly to the insurer. It also states that the obligations of an insurer who pays sums of money to a firm for the account of a client or the beneficiary of a client are discharged only when the client or beneficiary receives the money. The effect of Section 102 is that, for this administrative act, the insurance of persons representative is acting as mandatory of the insurer. This has significant practical consequences. The client will be released from the payment owed to the insurer upon delivery of the amounts owed to the firm or to one of its representatives. When the policy is delivered. When the insurance policy is delivered, the insurance of persons representative must check whether the insured is still in good health. If he notices significant changes in the client's insurability since the proposal was signed, he must not give him the policy. Instead, he must notify the insurer and wait for instructions. If, under such circumstances, the insurance of persons representative was to give the policy to the client would have reason to assume that the insurance came into effect. However, the representative would be liable towards the insurer. 4.1.4.3 Assuries. Assuries is a not-for-profit organization that protects Canadian policyholders if their life insurance company should fail. 302 life insurance agents must understand what would happen if an insurance company became insolvent. The insured is automatically covered under Assuries because all federally regulated insurers, and most provincially regulated companies, must be part of Assuries. If a company were to fail, the insurer's primary regulator would appoint a liquidator. It would first attempt to transfer the policies to other insurance companies. If the liquidator had to reduce benefits, Assuries protection would apply. The levels of protection, summarized here in Table 4.1, should address any client concerns. It is important to mention that these levels of protection are in force since May 29, 2023. 4.1.4.3 Assuries. Assuries is a not-for-profit organization that protects Canadian policyholders if their life insurance company should fail. 302 life insurance agents must understand what would happen if an insurance company became insolvent. The insured is automatically covered under Assuries because all federally regulated insurers, and most provincially regulated companies, must be part of Assuries. If a company were to fail, the insurer's primary regulator would appoint a liquidator. It would first attempt to transfer the policies to other insurance companies. If the liquidator had to reduce benefits, Assuries protection would apply. The levels of protection, summarized here in Table 4.1, should address any client concerns. It is important to mention that these levels of protection are in force since May 29, 2023.303. Table 4.1. Assurances Protection 304. Benefits ASSURIS Protection Additional Information. Death benefit $1 million or 90% of promised benefits, whichever is higher. Health expense $250,000 or 90% of promised benefits, whichever is higher. Monthly income $5,000 per month or 90% of promised benefits, whichever is higher. Investments, savings. Cash value, accumulated. Value and segregated. Fund guarantee. $100,000 or 90% of promised benefits, whichever is higher. 4.1.4.4 Ombud Service for Life and Health Insurance, OLHI. The Ombud Service for Life and Health Insurance, OLHI, is a national independent complaint resolution organization providing clients with assistance to their inquiries and complaints pertaining to Canadian life and health insurance products and services. In certain circumstances, OLHI may direct life insurance agent-related complaints to the appropriate insurers. 305. 4.1.4.5 Canadian Council of Insurance Regulators, CCIR. Similarly to CISRO, the Canadian Council of Insurance Regulators, CCIR, is an interjurisdictional association of insurance regulators. The mandate is to facilitate and promote an efficient and effective insurance regulatory system in Canada to serve the public interest. Under the supervision of the CCIR, Canadian insurance regulators have adopted a framework aimed at prioritizing the most important issues, based on the potential impact, risk, to the achievement of desired regulatory outcomes. 307. In managing key risks to clients, the regulatory authorities' priorities are being directed at Black small square strengthening the foundation of market conduct. Black small square implementing an enhanced market conduct supervisory framework. Black small square making the supervision of insurance intermediaries more effective. Black small square assisting clients through targeted financial education programs, such as fraud alerts and client information portals. As indicated by the Canadian Council of Insurance Regulators, CCIR, the framework includes both micro-level outcomes that are within the control of individual firms or intermediaries and broader systemic-level outcomes that can only be achieved through the collective actions of the entire industry. 308 In other words, companies or intermediaries may have an impact in their regions or on their respective customers, but a larger impact can be generated by the adoption of measures or regulations that apply to the entire industry. 4.1.5 Professional associations. There are also a number of organizations that encourage the professionalism of life insurance agents. These include the Canadian Life and Health Insurance Association, CLHIA, 309 Advocates, 310. The Independent Financial Brokers of Canada, IFB, 311 FP Canada, 312 and the Financial Planners Standards Council, FPSC, .313. These promote the obtaining of professional qualifications, continuous professional development, ethical behavior within the industry and fair treatment of clients. 4.1.6 International Association of Insurance Supervisors, IAIS. The International Association of Insurance Supervisors, IAIS, 314 representing insurance regulators of more than 200 jurisdictions in nearly 140 countries, has adopted 26 insurance core principles. ICP, with a view to promoting effective and providing globally consistent supervision of the insurance industry and contributing to global financial stability. It is a strategic initiative of CISRO and the Canadian Council of Insurance Regulators, CCIR, to ensure that the Canadian regulatory system meets all internationally agreed upon standards as well as to keep informed on emerging issues that may be identified outside Canada. 4.1.6.1 Insurance Core Principles, ICP, 18 and 19 of the IAIS. Insurance Core Principle, ICP, 18, entitled Intermediaries, covers the supervision of life insurance agents, and ICP 19, entitled Conduct of Business, the Activities and Behavior of Life Insurance Agents. The rules emphasized in these ICPs are for the most part reflected in the existing codes of conduct of most of the regulatory authorities and insurance companies with the view to protecting clients and supporting their best interests. 4.2 Main responsibilities of life insurance agents. This section identifies the main responsibilities of life insurance agents and how they are required to work within a business conduct framework that adheres to the Provincial Insurance Acts and the codes of conduct required by regulators, insurers and industry associations. 315. Ethics and professional practices should always be at the core of the activities of the insurance agent. Obtaining an insurance license is a privilege which requires that all agents respect and apply the principles and rules which are imposed by applicable legislation, codes of conduct, and contractual documents. It is fundamental for agents to always be aware that ethics and sound professional practices are not only an obligation but that any form of non-compliance can lead to stiff penalties, 316, which include applicable monetary penalties and even the revocation of an agent's license. The Insurance Council of British Columbia Code has the following introduction. The strength of the insurance industry is based, in part, on industry members providing advice and services to the public in a competent and professional manner. The underlying principle of all insurance business is utmost good faith. to command the confidence and respect of the public, the insurance industry must maintain a reputation for integrity, competence and good faith. Point 317. This introduction is a reflection of principles and rules set out in all the other codes of conduct across Canada. Principles generally motivate or encourage certain behavior, such as the obligation to act in good faith. Rules prohibit or sanction behavior such as the prohibition against forgery. An agent's conduct, practices and decisions can be guided by the following principles and rules. Black small square acting in good faith. Black small square managing conflicts of interest properly. Black small square refraining from unfair or deceptive practices. Black small square making full disclosure. Black small square acting in compliance of regulation. Black small square handling complaints in a timely and fair manner. 4.2.1 Acting in good faith. Acting in good faith or in a manner that is consistent with the client's best interests is a fundamental aspect of an agent's business conduct, as well as a key element in the guiding principles of applicable codes of conduct and ethics, whether mandatory or voluntary. The components of acting in good faith are black small square duty of care, black small square integrity, black small square competence. 4.2.1.1 Duty of care. It is the responsibility and obligation of life insurance agents to avoid careless acts or omissions. The Code of Conduct from the Life Insurance Council of Alberta states under duty of care that the client's interests take priority over the interests of the agent. 319. Example. After meeting with a client and completing the life application, Erica, a life insurance agent, was in a rush to leave on a long weekend trip. She locked the application and initial premium in her desk drawer. However, she forgot to submit the application after the long weekend. It was not until a few weeks later, when the client inquired about the status of the application, that she remembered it was still inside the drawer. Erica's action did not meet the standard of care expected of an agent, as she did not put her client's interests first. 4.2.1.2 Integrity. It is essential that life insurance agents act with integrity. These relate to qualities such as black small square being honest, trustworthy and fair. Black small square being reliable, dependable and respectful. The Insurance Council of Manitoba's Code of Conduct confirms that if personal integrity is missing, there is little an agent can do to compensate for its absence or to repair the damage to his reputation. 320. Example. Felicity, an insurance agent, helped a client apply for a multi-million-dollar permanent policy and collected the $100,000 annual premium with the application. Felicity believed that the permanent policy was not suitable for the client's needs, without discussing it with her client, but proceeded with the application at the client's request, as she was only interested in the commission she would receive from the insurer. Through her behavior, Felicity demonstrated a lack of integrity. 4.2.1.3 Competence. The codes of conduct stipulate that life insurance agents should only carry out business in respect to the products and services for which they have the required competence. If an agent encounters a situation where his knowledge and skills may not be sufficient to make a well-founded recommendation, then the agent has an ethical duty to either ask for technical assistance from a colleague or refer the client to someone who can provide the assistance. As the Insurance Council of British Columbia affirms, incompetent conduct can result in significant prejudice to clients and insurers. Example. Sandra, a life insurance agent, does not have experience in annuity products. She tells Amal, a prospective client, that she could prepare a customized proposal for a back-to-back insured annuity. This strategy, she says, will increase the client's guaranteed stream of income at retirement while minimizing the tax payable. Sandra has committed to provide information on a complex transaction without understanding what is involved. Sandra should have simply told Amal that she would obtain the technical assistance needed from colleagues in her agency. Together, they could have prepared a proposal that would have met the needs expressed by the client. The combination of care, integrity and competence, often referred to as acting in good faith, will not only help build the life agent's reputation, but it will also achieve the marketplace outcome clearly stated by the regulatory authorities, that clients be treated fairly. 4.2.2 Managing conflicts of interest. A conflict of interest is a situation in which a life insurance agent is motivated to take action by an interest other than that of the client, placing the interests of a client second to the agent's interest, is contrary to the expectation of all regulatory authorities that clients be treated fairly. Before clients agree on an insurance contract or receive advice from a life insurance agent, any potential conflicts of interest, whether such conflict is real or apprehended, must be disclosed and managed appropriately. The CCIR and CISRO require that agents address the following principles. 322. Black small square priority of client's interest. Black small square disclosure of conflicts or potential conflicts of interest. Black small square product suitability. To comply with these three principles, regulatory authorities have set them out in their respective codes of conducts, as illustrated below. 4.2.2.1 Priority of client's interest. The interests of the client must be placed ahead of those of the life insurance agent. According to the Insurance Council of Manitoba's Code of Conduct, a life insurance agent must black small square not knowingly prejudice the interests of a client for personal gain. Black small square not take advantage of a client's or an insured's inexperience or ill health. 323. Example. Martha, a group insurance agent, is married to Roberto, VP of Group Insurance Sales at a prominent life insurance company. Though she acts as agent for several life insurance companies, she often feels compelled to recommend Roberto's employer, as she knows that sales for Roberto's company may affect Roberto's performance bonus. In such a situation,